The America First Legal Foundation, combating the left's radical agenda.
Fight for the American people, defend the Constitution, and save this nation for the next generation. Hello, and welcome to this week's episode of The Arena with America First Legal. I am joined today by, once again, our Vice President, Dan Epstein, our Senior Counsel, Ian Pryor, and our special guest of the week, the one and only, the Honorable Assistant Attorney General for the Civil Rights Division at the Department of Justice, Harmeet Dhillon. Harmeet, thanks for joining us today.
Yes, thanks for having me. I'm really excited for this conversation.
Well, it's great. So, look, I know because I track y'all's work very closely, just as a person who's very interested in this, all of the subjects that you guys work in, from civil rights enforcement to voting rights to everything in between. Your division has been very, very busy and has been revolutionary in the way that it's approached its work. But I think that some of the folks at home might not understand, what is it that the Civil Rights Division does at the Department of Justice, and how does it compare to some of the other offices and departments and agencies that adjudicate civil rights issues for the American people?
Well, thank you for the question. So I'm very passionate about civil rights issues, as some of you will know from my law practice before. And so when the president and the former Attorney General Pam Bondi asked me right after the election in 2024 if I would step up and do this job, it was both exciting but also daunting, and for two reasons. And so, first of all, it's one of the largest litigating sections in the Department of Justice. So we have about half a dozen litigation sections in the DOJ, and the one that gets a lot of play for doing the defensive work is the civil division. That's sort of the most equivalent to in size to what I do. There's a tax section, antitrust section, environmental, and a couple of others, and then there's national security and some others. So civil rights division has typically been one of the largest of the litigating components, and that is because we are charged every time Congress passes a new law regarding our federal civil rights with enforcing those laws. And so when I was nominated, the Civil Rights Division had over 400 attorneys and another 200 staff, including paralegals, statisticians, and other administrative staff. Today, it's less than half of that. And the reason is that the Civil Rights Division has typically been the most, I would say, entrenched and liberal and really intractable sections of the Department of Justice. So no matter who's the president, the same lawyers have been doing the same thing, sometimes literally for decades, without change. And typically when a Republican comes in and appoints a head of the Civil Rights Division, and this is no criticism to my predecessors, but first of all of their friends tell them, you're not going to be able to change these people. They're just not going to change. So do what you can around the margins, make it from 10 out of 10 bad to 8 out of 10 bad, maybe, if you can. So that's what I was told, but I'm a little different character, and I accepted the challenge. And I think it should be 10 out of 10 good for the American people. Civil rights are important, and conservatives have come to think of civil rights as something bad that is done to them, as opposed to an affirmative set of natural and codified rights that we should all be enjoying as Americans, and we as conservative lawyers sitting here should be ensuring that all American citizens enjoy. So that's the approach that I took with the Civil Rights Division. And the reason we shrank in size significantly, although we built back quite a bit and we're hiring aggressively, is because my agenda, which is the president's agenda, was kind of radically at odds with the hidden and open agendas of the then staff at the Civil Rights Division.
Well, so I know that must be a tremendous challenge to you from a management and leadership perspective, because, I mean, there is addition by subtraction in some organizations and entities. If you get rid of some toxic people who are working against what's lawful and what's the rightful agenda of leadership, that can provide value. But that also, just in any kind of environment, that's a significant cut to staff. And so that certainly affects your ability to do good work, assuming that you have the equivalent number of right-minded attorneys who were willing to step in and do the work. And so if you came into your office on day one and you had 400 attorneys who were not biased and who were willing to execute the agenda of the leadership, that would be a dramatically different picture than what you were presented with, at least for the first year or so.
Oh, it would have been different, and I hope to leave it that way whenever the president is done with me. I hope that I will leave it in a place where we have a bunch of lawyers working there who are dedicated to protecting the rights of all American citizens. And so, quite a bit of what you see in the headlines of what we do is controversial or, call it, popular or high profile. But quite a bit of what we do, which I committed to do in my Senate confirmation hearings and when I took my oath, is not controversial. So, for example, disability rights cases or protecting the rights of our service members to be able to enjoy cross border licensure without undue hurdles when they move from one state to the other when they're deployed. Or, locking up autistic children instead of treating them with the, care and respect they deserve, or unconstitutional prison conditions. And so I think there are a lot of things there that everyone would agree on. But our civil rights division was so weaponized, and I think quite a few of them quit after seeing my testimony in the Senate confirmation and even knowing who I was going to be because, I have a certain reputation that precedes me. I'm not your average government lawyer. And so, but then when my second week occurred, the first week, HR training, don't harass people. Here's how a skiff works. Here's what to do in the case of a national emergency and where to go. This week two was let's get down to business. And so I think at the time there were 13 sections in the Civil Rights Division. We've consolidated some and added one, which I'm sure we'll get to. So I issued memos to each of them saying, I want to just reframe what we're doing here. And these are the statutes that we enforce in your section. So for employment, it was Title VII. For education, Title VI, so Title II, all the different titles out there. Um, and then these are the president's executive orders that are relevant to your job. And so please understand that these are our enforcement priorities. And these are short, sometimes 1 or 2 paragraph statements of purpose or mission statements. And I sent them to each of the sections. And, people just went ballistic and, couldn't believe that they were asked to stop prosecuting Catholics praying outside an abortion clinic and instead be more open, even-handed in that. And we were going to start enforcing that portion of the 1996 FACE Act that says that houses of worship are protected by it. Had never been enforced
Right.
in 30 years. 20, like 40 years almost, 30 years, yeah. So these are some of the things that we did that caused a lot of people to quit, put in their notice. And at the time, you may recall, due to Doge, there were policies out there giving people, in the case of DOJ lawyers, 5-month packages where, so they, if you're a senior lawyer, that could be around $100,000 with bonuses and so forth. And a lot of them chose to take that. And, some didn't. And we then had needs in some departments. So we moved some people around. So suddenly some folks had been used to, doing things in their pet way. Special litigation was the giant slush fund for go after the police. And, people had made their entire careers in this euphemistic special litigation. The only thing special about it was that it, made every community more expensive and less safe if the DOJ chose to go after you. Not very special. And so, people then quit over that because, like,
Right.
we need people handling this, we need people handling that, and they didn't want to do that because in a law firm, you don't get to do that. You're assigned to a case because there's a need, and your boss says go do it. Like, no, I'm too precious to do that. I want to do this other thing. No, it's not. That's not how it works.
Right.
So, look, and I also don't need to be liked. I just need to get the job done. So that was kind of my attitude going in. So we broke some eggs, hurt some feelings. There were some, they had unhappy hours, over in, there were some, mass departures, and they had crying sessions, and they have a support group outside of lawyers who've left the Civil Rights Division. They meet regularly. They place media hits on us. They monitor every filing. They flag it for, our opponents, and some of them talk to the press in manners that are unethical, according to bar rules, revealing internal processes and so forth. And so this has been some of the ongoing challenges in managing. Now, Other departments have had some of this, but we really had the most controversial issues, going after the police, going after, stopping the DEI that infects America's corporations, police departments, universities, you name it. So, naturally, we've had some of the most aggressive blowback from the changes we made to implement the president's agenda.
Yeah, one more question from me, which is just to draw kind of an analogy, like you were just saying that if you're talking about your workload at a law firm and you're an associate or you're a partner, or anybody, and you say, you know what, I don't want to do that. I'm better. I have other things to do. It wouldn't work out so well for you. In a parallel to talking about the ethical obligations of attorneys, I've always been struck by the notion that government attorneys, particularly in places like the Civil Rights Division historically, have found that they thought that they could just share privileged and confidential client information with media sources and leak things. And it's just not isolated to civil rights. It's present in lots of different divisions within the department, at least when I was there, and across the government. And, do you have any thoughts on kind of the obligations of an attorney when it comes to you're a government lawyer, but you don't shed those responsibilities to your client, and your client ultimately gives you information, or you obtain access to information. The notion that you're just a government lawyer and that gives you free license to share and to leak and give information to the media strikes me as being completely unethical and completely at odds with your obligations as a lawyer.
Well, you're 100% correct. Now, why do people do this in the face of clear ethical requirements? We all have to take ethics, continuing legal education. We're members of bars. I'm a member of 2 bars. And why do people do this? Well, first of all, DC has its own rhythm and currency, and the currency of DC is information. You may feel like you're toiling away in obscurity, or you hate President Trump, or you hate Harmeet Dhillon, and your only outlet is going to be talking to this friendly lawyer who wants, not lawyer, but journalist who wants to sidle up to you. And suddenly you're important. And so a lot of people get importance from that. I certainly get approached by media multiple times a day. And, so there's a temptation on the part of some, low and high, to succumb to that. I mean, it's a temporary dopamine hit to have a reporter ask your opinion or something. But it is unethical. And unfortunately, the tone has been set by as senior government lawyers as James Comey,
Mm-hmm.
who
Right.
stole documents and gave them to the New York Times. He's admitted this.
Right.
People steal documents for their memoirs, and so forth. And so it's unfortunate. Now, some of the challenges we have is we have a process for professional responsibility. There's Office of Professional Responsibility at the Department of Justice. Well, supposing that person quit and, you're having, trying to find someone to replace that person, or supposing their attitude is, I've yet to see a government lawyer committing a Brady violation or a leak or an ethical violation that I'm going to find sufficient to have them removed from their job. So let me just say that even the types of normal processes that you would go through in private practice, if this happened and I saw the other side doing this, I would just flag it for the judge and call the bar.
Yeah.
I mean, we can't do that. We have manuals and processes and offices and bureaucracy, which is frustrating for those of us who are CEOs in private practice. So that's kind of some of the challenges. So are people getting punished? I will say that in our FACE Act review of what happened in that situation, some people did lose their jobs for violations of Brady and other ethical violations that they committed. But, I don't think any bar sanctions have been applied.
You mentioned civil rights traditionally as sort of the anti-police, and I can attest to that. When I started at the Department of Justice in public affairs, and it was at the beginning of Trump's first administration, what the Obama administration did was they entered into all these consent decrees, and then they left it to us to actually announce them. And I'm like, what is the civil rights division? Is this just all about going after the police?
Yeah.
And yes, and I remember it was the Baltimore consent decree, and this sort of first opened my eyes to this issue, where the micromanaging of law enforcement, it got to the level of officers couldn't refer to somebody as sir or ma'am when they pulled them over because, like, God forbid you offend Johnny, the non-binary sex trafficker, right? These are the kind of things that the DOJ was doing in the Obama administration, and then certainly in the Biden administration. Great that we're not there now, but what are some of the priorities that the Civil Rights Division is tackling that are getting the pushback from the left, from the people that really just want to spend time going after the police?
That are getting pushback?
Yeah.
Okay, so let me first say what we're doing in this regard. It goes back before the Obama administration. It has been the job of the Civil Rights Division for decades to, go after the police. And not just the police, the other species of consent decree that litters the dockets of America's federal courts is school consent decrees. And I will say there was a time, and I grew up in the Deep South in rural North Carolina in the 1970s. It was kind of segregated, let's be honest. It wasn't legally segregated, but, it was not exactly a great situation. By the time I left, it definitely was much better. But so, we had Dixiecrat governors who were refusing to honor Brown v. Board of Education. So the United States Department of Justice did the correct thing, going in and forcing them to follow federal law. I view what we're doing in that regard today being like in the gun area and some of the other areas. We're having to do the same thing where governors, mayors, city councils are simply refusing to follow the law, DEI, guns, and so forth. So there's a lot of pushback there. But in order to, I think, have an efficient administration of justice, you actually also have to get rid of all that crud. So we have systematically analyzed every consent decree that the United States Department of Justice Civil Rights Division is currently in and made a determination as to whether it should be dismissed. And I have one very senior lawyer on my team who, this is his last job in his career. He sold his law practice. He joined me. He's also from a political background, former member of the Republican National Committee like me. And he's doing what he calls the reverse Sherman March, which is one by one dismissing. And I get an email from him a couple of times a week. He's like, Connecticut has fallen, and so, we have gotten rid of a consent decree that is outdated, unnecessary, overreaching, etc. At the beginning of the Trump administration, what we did is we had like 8 or 9 consent decrees that had already either been filed with a court or findings had been made, and the lawyers were ready to make filings in court. And we analyzed them and we withdrew them. We found them to be statistically unsound and also micromanaging. There's also something, and I gave a press conference about this, called the Ferguson effect. The Ferguson effect is whenever there's a consent decree involving police practices, first of all, the cost of policing goes way up. The job satisfaction of police goes down, so they become understaffed. And then they have safety goes down. Albuquerque is a notorious example of this. And they had a situation there where over a 20-year period, they had some, 2 cops did something bad or 4 cops. And suddenly everybody in the whole community has to pay for decades. And it makes no sense. The cost of a consent decree for a community is at a minimum $1 million a year. It can be as much as $10 million for a larger city. And here's the dirty secret that nobody ever tells the public, which is consent decrees are typically administered by private lawyers, sometimes from big law firms. And it is like a coupon. It's a sinecure. And they're the ones who certify whether you're in compliance. Well, guess what? If you're getting paid $1 million a year for doing nothing and you're having junkets in, New Orleans and getting drunk and getting arrested there, a true fact in the case of one of our notorious repeat monitors, you're never going to find that the city's in compliance. And so we've had to force that through over the objections of some of these monitors. And we aren't done. We have to convince judges. Sometimes the judges don't want to do it because it's either their friend or they don't want to be on the wrong side of these issues. But one by one, by the end of this administration, I think you're going to have almost no consent decrees on the books that don't belong. Now, there are instances where there's systematic misconduct, and it's our job to stop that. And I'm, over the years of being a civil rights lawyer, I've represented criminal defendants in appeals or due process issues, Eighth Amendment issues, and so forth. And I'm glad that conservatives are starting to care about the rights of the accused, because we're accused now sometimes. And a lot of conservatives never knew anybody who'd been arrested for a crime. And now we've seen that can happen to anybody and how important those constitutional rights are. So it is important that there be a vigorous Department of Justice that has the ability and the will and the skill to go after these violations. And at the same time, should not be making it miserable to be a policeman, and should not be making it unsafe to be a resident of a city where one cop did something wrong.
Speaking of schools and sort of new areas of law, obviously over the past several years, we've seen this. These schools will have these policies that allow the teachers, the staff to transition children without the consent of the parents, without informing the parents, that allow children to use bathrooms of the opposite sex. And then they tell the girl, well, you're the one that's got to figure out something, right?
Right.
We've had some good decisions come down from the Supreme Court, from other courts saying, well, you can't do that. And maybe we're expecting another good decision in the West Virginia versus BPJ case. But what I've seen is that these schools don't care. They do not care what the Supreme Court says. They will continue to do it. They will make tweaks to whatever they're doing. And they'll say, we're in compliance with the law, when they're clearly not in compliance and they're violating the constitutional rights of parents and their children. What is the Department of Justice's role in enforcing some of those constitutional rights?
Well, so that's an interesting question. So there's some differences of opinion in different lawyers in the Department of Justice. Everything I do that involves constitutional issues, I need to run by the Solicitor General's office and sometimes Office of Legal Counsel. So these are the brainy nerds down the hall. I love them, but we have vigorous discussions about whether certain things are within our enforcement authority or not, or whether we should be waiting for the court to make its rulings. Is this the right vehicle? Is the usual phrase you hear from appellate gurus. And sometimes the answer is no, Harmeet, it's not the right vehicle. So I have personally represented parents and children who have been subject to the type of behavior you have described. And I've won settlements in those cases. It did not go all the way because schools saw exposure. But, this is a target-rich environment. After I won settlements in cases like that, California effectively emancipated 12-year-olds. 12-year-olds can declare that because their parents aren't supporting their transition, they can go to a gender shelter and be emancipated and have the state effectively become the parent. I mean, this is at odds with not just recent, but constitutional case law that goes back several decades to, I think one of the notorious cases is whether parents should be allowed to teach their children German. Answer, yes, from the Supreme Court. State has no business directing the education of children in matters of that nature. And so I think, I would say typically for this type of case at this point in time, we could file statements of interest or intervene, but we're not typically the plaintiff because, does the United States have standing in a case like that is a question that I think is debated. But that said, we have an interest in these constitutional rights, and there's often a religion aspect to it or a gender aspect to it, which we do have jurisdiction over, as opposed to just sort of the pure question of what parental rights are vis-a-vis the state.
And just following up on that, can you clarify on sort of the religious and gender? Is that because it's subject to the Equal Protection Clause and that?
Equal protection or other statutes that will apply, like Title VI. So, for example, if girls are being forced into conditions that violate their privacy or interfere with their ability to get an education that is equal to what a male would get, that could be a Title IX issue. So Title IX applies to K through 12 as well as our higher education. And then equal protection, regarding gender as well as a theory. Religious discrimination is a First Amendment issue that we can take an interest in as well. But generally speaking, we have to fit into one of these statutory buckets with few exceptions.
Senator Mazie Hirono has said, and Gene has been subject to this, that diversity, equity, and inclusion practices are not unlawful. Why are they unlawful?
Well, they have a euphemistic label, so I want to be very precise about what we're talking about. What we're talking about, I believe, is equality of outcome as opposed to equality of opportunity. And equality of outcome in any type of institution that is more than two, really requires quotas and a zero-sum game of trading group rights against one another. And that's why they're unconstitutional, because our Constitution guarantees individual rights, and individual rights are at odds with Asians get to be called low personality as an excuse for not admitting them according to their merit in institutions of higher learning that are funded by the United States, which is all institutions of higher learning with very few exceptions. And so that's the problem with it. And then it is the same problem in Title VII and in federal employment law and state employment law as well, that it is unfair to say, well, we need to have a workforce that reflects the population. Well, why is that? What if a lot of the population didn't go to high school and are drug dealers? Is that how we should be balancing the workforce? What about Bob, who worked hard and happens to be a white, straight male? And why isn't Bob getting a fair shake? So that is a problem with it. And of course, Mazie Hirono thinks that. I mean, she comes from, a state where I think that kind of set aside mentality is rife, and that's the Democrat Party's viewpoint. And again, historically, and again, I will say at the beginning of when you had some of this affirmative action programs, you had typically public employers like police departments, fire departments. They were discriminating.
Mm.
Okay. So, there was a period of time when they tried to fix that by doing various things. Eventually, they got rid of tests. That's not a good thing because the tests were found to be discriminatory because the outcomes of the test. Some people were passing, some weren't. That's not discriminatory. It's just that goes back to how bad our educational system is
Right.
for our inner cities, and minorities get terrible education in this country. So the way the states have dealt with that is simply stop counting and not have numbers associated with them. Everyone gets a trophy. Harvard is doing that now,
Yeah.
so grade inflation and all of that. So that's why it's unconstitutional.
Again, just back to where we started. You would think that all things being equal, everyone would agree with the work that you guys are doing in the Civil Rights Division, trying to ensure equal rights and equal opportunity for every single American across the country, and in the exercise of those rights across all statutory and constitutional protections. One issue area that hasn't gotten as much attention from the Civil Rights Division historically has been when it comes to other constitutional guarantees. I don't know, like the Second Amendment. Could you explain for the folks at home kind of what your division has stood up and what you all are doing when it comes to the Second Amendment and protecting people's civil rights there?
Yeah, absolutely. So, I want to make an overall point, which is a lot of people hear, oh, Civil Rights Division, and that's our people now. So this is like the help desk for all civil rights issues in America. We're not the help desk.
Right.
We're not legal aid.
Right.
And of the thousands of issues and emails that come across my desk in a month, I can only take a handful of those. It's very similar to your organization and in private practice at a law firm. We just can't take all the clients. So we look for cases that I call impact litigation cases, where you can have an oversized impact with your choice of case and your choice of venue. And I've been having to explain this a lot in the Second Amendment space. So our job at the Civil Rights Division, historically and today, is mainly to go after states violating
Yep.
the rights of their citizens,
Right.
sometimes localities. So our typical targets are states and municipalities, or institutions funded by the federal government or recipients of federal funding. So proxies for the government in that sense. So where a state is violating or a city is violating the rights of its citizens on any, area where particularly police power is being used, so police are violating the rights of the citizens, that is the theory under which we're going after violations of the Second Amendment. There's a lot of hue and cry over whether that's appropriate, because it's never been done before. The fact that it's never been done before doesn't make it inappropriate. It makes
Bingo.
it creative lawyering, and that's
Yep.
what it is. And so that is what we're doing, is we're saying, this last week, I sued both Denver and Colorado on two separate infringements of the Second Amendment. The first case we filed in this regard was against California's Los Angeles County Sheriff's Department, which in the wake of the Bruin decision of the Supreme Court, I think 2023, where we switched from a may issue with a bunch of hurdles to a shall issue regimen for concealed carry, um, you know, 3 years would go by between the time you applied for your CCW permit and in LA, paid your fee, proved that you're not a criminal, still didn't have your permit because they had like half a person assigned to doing it. And I've tried to explain this to people, pretend like it's the First Amendment.
Right.
Pretend like you want to have a protest against guns next week and you need to get a permit from City Hall. Pretend like they had one person assigned to do that and they only worked 1 hour a week and there was a backlog and you wanted to protest next week, but you got your permit 3 years from now. That's the same thing. You're not being allowed, you're effectively being denied your constitutional right because of the delay. And so we first did an investigation. That's how DOJ works. In private practice, I was more like sue first and find out later. But in our investigation, they gave us some data. The data showed that they were taking forever to do this and they had not insufficient staffing. So we sued them over that. And so there have been a couple of other cases like that. But let's talk about some blatant violations of the Second Amendment would include multiple jurisdictions that have so-called assault weapon bans. Colorado Denver has a so-called assault weapons ban. Colorado has a large capacity magazine ban. By large capacity, Colorado means standard capacity. So the capacity of the firearm that you bought, suddenly they want to make it inoperable to force you to buy a smaller magazine. So I think it's 15 round maximum. AR-15s have typically 30 rounds or other type of semi-automatic rifles, which are the most popular rifles used in the United States. And they were outright banned in Denver. They're outright banned in DC, and they're outright banned in some other jurisdictions. Virginia just passed a law like this. We're, waiting for it to come into effect before we challenge it. It's already been challenged by some other jurisdictions. And so, so these are the types of things that we're doing. And make no mistake, this affects millions of Americans. It affects millions of firearms. I personally argued in the Seventh Circuit against Illinois' assault weapons ban, so-called assault weapons ban. That we've also added in our DC litigation just this week a challenge to their complete ban on suppressors. So, this is revolutionary.
Yeah.
Never in the history of the United States has the federal government stood up on the side of the taxpayer and the citizen against the state and the locality challenging. And what's interesting also, which I love about this practice, is you look at DC. I went and applied for my own CCW here, and I had 4 firearms that I brought from California. And it took me less than a week. I mean, they cleaned up their act after
Wow.
these cases. And not that I came in saying, here's my DOJ badge.
Right.
I came in wearing a T-shirt and jeans, and I hadn't really flagged I'm a VIP or anything.
Right.
And they gave it to me, and every other person there, African American, business owner, person living in a community who just wants to be safe.
Yep.
And so delays affect that community.
Right.
Look at the Virgin Islands, U.S. Virgin Islands. We have a lawsuit going similarly. They were simply ignoring Bruin, requiring people to prove their worthiness for a CCW, buy a safe, invest in all of this stuff before they got their permit even. And this is illegal. Also affected mostly minority Americans.
Right.
Los Angeles County, a lot of minorities of all different backgrounds there.
Right.
And so I think this is just one of the most important and revolutionary changes to the Civil Rights Division is this neglected right. And every day we have new, it's just a target-rich environment, as someone said
Yes.
the other day. But, we have to be strategic.
Right.
Almost every jurisdiction is violating our rights in some way. So
Right.
sometimes we do it with an amicus brief at the Supreme Court. So we were in the Wolford case, the Hawaii, which flipped the presumption of whether you can carry on private property as to having to get permission as opposed to the permission being presumed. And so there are other jurisdictions who have similar laws. And so when you pick and choose and you get the right cases up there, they have an immediate impact in a much broader than just the one case. So here, what we're trying to do with our Colorado litigation is there is no current ruling from the 10th Circuit on whether AR-15s or similar semi-automatic rifles are protected by the Second Amendment and presumptively legal. There are negative rulings in some other jurisdictions. And so hopefully there'll be a circuit split that would invite Supreme Court review. And the current court has really tipped its hand pretty clearly as to what the answer to that question is going to be, because in a 9-0 ruling within the last year in the Smith and Wesson case, all the justices agreed that the AR-15 is the most commonly used firearm in the United States.
Right. Well, so what I hear from you, and correct me if I'm wrong, what I hear from you is that your priority, of course, is executing the president's agenda, but protecting all rights for all Americans that you have been charged with doing as
That's
the
right.
head of the Civil Rights Division. So again, from my perspective, it seems kind of uh, insane or crazy that anyone would criticize you for the things that you guys are doing, because you are going out on a limb and protecting Americans against this asymmetric kind of power imbalance that they've had with some of the states and localities as applied to any number of the individual rights that they are guaranteed under the Constitution and laws of the United States.
Yep.
So let me ask you this. This is another thing that you mentioned earlier, and I think I share this view a lot. I think the conservative movement, the conservative legal movement, for the longest time, just completely disregarded civil rights as an issue area, and very similar to the way that they completely dismissed immigration law, and they just kind of set it to the side as the other. So if you're making the case to a young lawyer or to a law student who is trying to decide what they want to do with their life, why should any young conservative lawyer get into civil rights? What kind of difference can it make? In what types of opportunities might they be able to pursue at a place like the Department of Justice?
Well, that's a very interesting question, and I will say that even though the work that we're doing is very popular, there is some kind of sclerotic thinking even among some conservative lawyers in this administration. I mean, I showed up in April, and my budget had been slashed because somebody's idea was, well, let's just deal with this problem by simply cutting the budget of the Civil Rights Division. Well, it's not like that anymore. I couldn't do the job with the tools I had, and everyone above me was immediately supportive, and we've gotten what we need, and just don't have enough people to do the agenda that we have. But even that problem is solving itself. Now, there's two aspects of why it is exciting, fun, and righteous to be a civil rights lawyer. First of all, the subject matter that you're working on, and it's almost like being a pioneer in the wild, wild west. There's a lot of uncharted territory out there. There's a lot of opportunity to be very creative and make new law. To me, that is very exciting. It is very exciting to go into court and argue a case of first impression, whether it's at the trial court level, the intermediate appellate level, or of course at the Supreme Court level. It's an incredible rush to have your name on a case. I mean, I had 3 cases during COVID, which I was involved with, where we challenged COVID restrictions, and someone asked me what was it like to argue. I said I didn't get to argue it because grant, vacate, remand 3 times, and we won those cases, and we brought in the rights of American citizens to be free from undue government burdens in their houses of worship. Gavin Newsom was not allowed to shut down the churches, was not allowed to stop people from doing Bible study together, and was not allowed to arrest people for praying in a parking lot. Not allowed. And, lawyers had to go to court to do that. Now, most conservative lawyers, are kind of conservative in the small c sense. They want to make a ton of money. They're not smart enough to be bankers. They want to make a ton of money in big law, defending the bankers or whatever. Like I did that at the beginning of my career. I did Viacom versus Paramount as a junior associate at Sherman and Sterling, and that sounds sexy, right? It's sitting in a conference room reviewing thousands of pages of due diligence with your friends and eating pizza and working for 12 hours a day. Not that exciting. But going to the Supreme Court and establishing an expanded view of the First Amendment, very exciting. So if you're that kind of person, there's that. Secondly, being a plaintiff's lawyer is just you get to be so creative, and you get to draft the complaint, not just respond to the complaint. I mean, it's just a totally different mentality. Many of our federal statutes that I administer have fee shifting provisions in them. You can learn skills that will allow you to make a lot of money while doing good and pick and choose your clients. In a big defense setting, in a big corporate law firm, even if you're a partner, you probably don't get to pick your clients because there's some big dog partner ahead of you who has a relationship with a polluter or a sexual harasser or some other person you'd rather not be spending your time defending all day for 12 hours a day. And you have to work on it because that's
Right.
where your bread is buttered. Well, it's not like that in plaintiff's litigation, where You bring the you decide if you're going to take that case. You design the case. Maybe you have a very talkative complaint that tells a story in your complaint. All creative, all fun, and then you get paid well if you succeed at the end of the day, and you get to talk about what you do, and you get to be excited about it. So now some people are very excited about security stock drop litigation. If that's your thing, God bless you. But if it's not your thing, and you want to be a mover and shaker and a person who makes things happen, that's being a plaintiff's lawyer. And civil rights litigation is a way to do that.
So, a lot of your targets will lawyer up because they say, "Oh, look, Harmeet's coming." So, schools, employers, all lawyering up, typically with big law firms, and they just say, "We're going to handle this issue," and we've got another 2.5 years of her. How do you make sure that this is a long-term thing, that the Civil Rights Division, even after you're gone, continues to protect the laws, continues to make sure that bad actors don't do these things?
Yeah, that's a great question. So first of all, to all the defense lawyers out there, you're welcome. I've definitely become a full employment act for typically conservative lawyers who have no qualms about defending DEI and other nonsensical things. They should know better, but they are, and it's good business. But I can't. It's just like every other thing in the government. It's like our EPA mandates or our open border versus our closed border. Politics matters and elections matter, and if we don't win elections, we will not be able to maintain our agenda, no matter who, because the next administration is entitled to have lawyers who are carrying out their agenda. I would no more advise my lawyers who join me because they love the work I've done historically, and there are a lot of those. There's dozens of lawyers who came because of our reputations in civil rights litigation. I wouldn't say, hey, stick around and undermine the next administration. That's not right. If you don't agree with what you're being asked to do, respectfully move on and start your own private law firm doing that stuff. It's a perfectly honorable way to comport yourself. And maybe you come back later. That's fine. That happens. So, but that said, what's I think more important is the president appointing judges who enforce the law and make durable change. So if we continue to have, now we've had 3 decisions from the Roberts Court in recent years, Students for Fair Admissions talking about DEI in the educational space. And then you have Ames versus Ohio Youth Services applying the same revolutionary principle. I've been an employment lawyer for over 3 decades. And in California, I've managed to, bring cases involving political speech and other issues and representing all kinds of people. But this concept that you didn't have a higher burden just because it's a majority plaintiff versus a minority plaintiff is revolutionary. And that is the law of the land currently. That is going to affect a sea change of litigation and employment space. And different staffers in the DOJ are not going to change that because the law is what it is. And then third, you have, these gun cases that are, I think, are very important. That's not not just gun cases. And fourth, I would say you have the voting rights cases. And Louisiana versus Calais is a revolutionary update to Section 2 Voting Rights Act jurisprudence, which says we are not just going to assume that America has to continue to correct the wrongs of the Reconstruction era through the 1960s. We are going to give ourselves a pat on the back and look at data and agree that we don't have to keep, putting people in race buckets and then adjusting outcomes. So that's the law. So if, God forbid, somebody with an opposite viewpoint becomes the leader of the country, there's still a court there. Now they're going to try to pack the court and do this, that, and the other. So elections absolutely matter. There is no way to ensure that what we're doing today will continue to be done into the future, absent good policy being in place and also picking the right people. Because let's face it, there are quite a few people who come into government, they do it to get their resume bumped up, and then they go trade on that immediately. So you need people who are actually super excited about the fundamentals of what we're doing. I mean, I personally intend to continue to go back to my private practice and nonprofit and do the exact same things I was doing before, but, perhaps with a few more gray hairs and maybe some colleagues who are more enthusiastic about it because I evangelized about how fun it is to do this.
That's really, really amazing to hear, because that is exactly the type of person that the country needs. It's exactly the kind of person that the conservative legal movement needs, or people who are willing to step in to litigate these cases and to step away, like you said. I mean, if you're a staffer in some government bureaucracy and you have an opportunity to leave, say, God forbid, it's some crazy person who becomes president, they're entitled to staff their own administration. You can go sue them, go sue their administration, go sue their and try to stop their policies and try to go help people. There's not necessarily any kind of glory that one obtains by being a martyr, a bureaucratic martyr by staying in office.
I do want to make one point,
Yeah.
if I can,
Yeah,
which
yeah.
is about how um, the most important changes in our civil rights laws have come at the end of brave lawyers throwing themselves at it repeatedly, losing quite a bit. And it's like you have a lot of pearl clutching from my Solicitor General colleagues because they don't want to, get a little spot of coffee on their win-loss record. But you cannot make new law without lawyers being willing to take risks. And so I'd love to see more conservative lawyers who are
Yeah.
willing to take risks and take on the establishment, because Bruin and Heller came after 2 decades of gun lawyers
Yeah.
throwing themselves at it repeatedly and failing and then finally winning. So
Well, I mean, certainly in a parallel context, the ACLU didn't make the progress that they did over the century of their
Brown v. Board of
existence.
Education and Thurgood
Exactly.
Marshall taking that on. I mean, that's where I learned it. I was actually on the board of the ACLU 20 years ago because I
Yeah.
didn't like the Patriot Act. So
Yeah.
that's where I learned about impact litigation and how important it is.
It's very important, and you have to be if you want to make change, you have to be willing to take a loss,
That's right.
and you have to just be willing to pick yourself up and keep going.
That's
Right?
right. That's right.
Well, look, I know that all of us here at America First Legal really appreciate everything that you're doing, that you've stepped into public service, revolutionized the Civil Rights Division. Just speaking from personal experience, I remember it from the first term, and it appears to be, from what I can see, night and day difference, even between then. With no disparagement meant to my colleagues who were there at the time, this is just a very, very different era. And it's thanks a lot to your leadership, to the president's leadership, to everybody in between. It's been really great. So thank you for joining us today. We really appreciate everything you're doing on behalf of the American people. And we hope to see you around soon.
You absolutely will. Thank you so much for letting me talk about something I'm so passionate about.
Thank you. All right. Now it is time for this week's Bad Legal Take.
From viral bad arguments to headline mistakes, we're calling them out on Bad Legal Takes.
So I'd like to propose today's Bad Legal Take as actually, in sorry to say this, bad legal take on the part of the Supreme Court of the United States in the case of Florida versus California and Washington. And if you are a person who is so inclined, I would highly recommend that you look at Justice Thomas, his dissent from the Supreme Court not taking this case, joined by Justice Alito. So why do I say this is a bad legal take? Well, as a little bit of history, you guys correct me if I say anything incorrect, especially our law professor sitting over there. Under the Constitution, the Supreme Court is a court that has original jurisdiction over certain matters. One of those certain matters that it has original jurisdiction over are disputes and cases brought between two states. So when a state like Florida, in this particular case, sued the state of California for the state of California's lax policies related to the issuance of CDLs to people who are not citizens. So state of Florida suing state of California saying, look, our citizens are being harmed in Florida by your policies in California. Where else is the state of Florida supposed to go? Well, again, under the Constitution, they would go to the Supreme Court. You have a majority of the Supreme Court say, we decline to take this case, as if they have discretion in the matter. As if original and exclusive jurisdiction means anything other than original and exclusive. And so I guess the question is, where else are states supposed to go? If the Supreme Court's going to decline to take a dispute between two states, I mean, do they have that luxury? Do they have that right under the Constitution? I would say not. If you have original and exclusive, that means that's the only place that you can go. And thinking this through, the way that at least I think some people say that certain justices think things through in terms of practical effects, in terms of the ripple effect on the court's legitimacy. This leaves no recourse for states if there's a dispute in the future. This leaves no peaceful recourse. I'm not saying that there's going to be some kind of an armed conflict. What I'm saying is repeated over and over and over again. What are states supposed to do? All it's going to do then is it's going to aggrandize the power of the federal government, and it's going to cause the federal government to expand into areas that, quite frankly, it probably doesn't even have the authority to get into. Because if a state can't challenge another state, if a state can't redress its wrongs against another state before the Supreme Court, then the only remedy is for some enterprising congressman or senator to come and propose some new regulatory regime or some new construct that is going to solve the matter instead of leaving it between the states. So that's my bad legal take. What do you guys think?
Yeah, I mean, look, right? I think it's a good point because what it essentially signals is, the states have to go to federal district courts, and then you're going to have battles over whether a given venue, whether there's personal jurisdiction over the other state defendant. And that's going to get tied up, and you're never going to get to the merits. The whole point of original jurisdiction issues between states, controversies affecting ambassadors, is because you don't expect the lower courts to be able to resolve these kinds of cases that inherently involve questions of national importance that couldn't be resolved by the lower courts. And so I think the Supreme Court declining original jurisdiction area, exactly as you say, spells bad news for future cases involving conflicts between states.
What's crazy is you remember Law in a Flash, the series of index cards that you had in law school that you used to study for law school exams or the bar exams. Well, when you had civil procedure, within the first 10, this was one of them, right? And it was one of those where you're like, all right, well, this is easy. You just remember the things that has original and exclusive jurisdiction on, and you're going to get that question right. And the question is never asked because it's so easy. Well, I guess not anymore, right? I guess they're going to have to expand that series to explain this.
I just don't understand the concept of Congress, or not Congress, but a constitution giving exclusive jurisdiction to a body, and then the body saying, yeah, sorry, not so much. Kind of like the president. I mean, they have the take care clause for the president, but the whole notion that the president can just, hey, you know what? Actually, that whole thing, I don't feel like doing that. I don't really feel like doing this. We dealt with this with the Biden administration's border policies and the Obama administration's border policies. Oh, I'm not going to force those, or I'm not going to deport illegals. I don't really actually feel like doing what Congress or what the Constitution has vested me with responsibility for doing. So that's my bad legal take this week. Ian, I think you had one.
Yeah. So many people may be familiar because we've talked about it with the case Mirabelli versus Bonta. And this is a case that went all the way to the Supreme Court from California Federal District Court that enjoined the school system from keeping secrets from parents related to their kids' gender identity or transitioning kids without consent of the parents. Goes up to the Ninth Circuit. Ninth Circuit vacates the injunction, but then the Supreme Court reinstates it and says, look, you cannot engage in unconsented social transitions of children to a different sex without the parents being, one, involved, or two, their consent, right? Okay, so now we're back at the Ninth Circuit where we're playing this out, and the Attorney General of California, Rob Bonta, says, well, the injunction we don't have to actually tell the parents if they don't ask. Well, how do you get consent if you don't tell the parents, right? I mean, it's basically that what they want to have is say, well, look, if the parent asks, then sure, we'll tell them. But in the 90% of cases where the kid's like, I'm just doing this at school and not at home, and the parent doesn't know to ask, we're not going to tell them. We're still going to facilitate this by allowing kids to use whatever bathroom, locker room, or pronouns they want. And we're going to completely violate the law because we're not getting consent because we're not telling the parents. It's absolutely insane what the state of California is doing here. They're going to lose. Just follow the law. Why are they dying on this stupid hill?
It's like ignorance of the law is an excuse for California to not inform parents. It's crazy.
Yeah, I mean, look, I think that's wild. I mean, and I think he's going to be wrong. He's going to be proven wrong at the end of the day as this case continues to progress. I mean, I'm just trying to think of an analogy. Like, I mean, not perfect, but if you bought a lotto ticket, and it was a scratcher or something, at the gas station, and you scratch off your thing, and you're not sure what's going on, and you hand it to the guy behind the counter, and you say, "Do I have a winning ticket?" And he doesn't tell you one way or the other, and then he keeps it for himself. And then you're like, oh, okay, well, I didn't. I guess I gave him my ticket, and I voluntarily gave him my ticket. And then you leave the store, and then the guy comes in. He's like, hey, look, I've got $100,000 winning scratcher ticket. I didn't tell him that it was a winning ticket. I didn't, and I just kind of didn't do anything. And that he gave it to me. It might not be a perfect analogy, but it's a similar construct where there's no consent. There's no consent there from the person who purchased the ticket. The store owner is converting it to his own resources. And in the similar case with a school, there's no consent from the parents. The school is basically running a policy and treating the child as if it's their own at that point in time, as if they have no obligation to tell the parents about what's going on. It's crazy. So I think that's going to be all for us today on this week's episode of The Arena with America First Legal. Stay tuned for another great episode next week. Contact us at thearena@aflegal.org with any suggestions, comments, or tips for future episodes. Until then, we will see you all later. Thank you very much.